Okay, imagine this for a second. You're young, you've been through something serious, a crime, you testify in court, which takes courage. But later, maybe you have second thoughts, maybe you want to change what you said. Can you actually do that?
It's a really tough question, and it touches on some fundamental aspects of how our justice system works.
Exactly. And today, we're doing a deep dive into exactly this kind of situation, looking at a pretty significant ruling from the Kerala High Court. It's recent, dated July 30, 2025.
That's right. And this case, it gives us some really clear insights into how courts handle witness testimony, especially, when minors are involved. And we're talking about serious charges under the POCSO Act. That's the Protection of Children from Sexual Offenses Act.
We've actually got the High Court judgment right here. So our plan is to unpack it, pull out the key bits about judicial integrity, what the law says about a minor's consent in these situations, and why the courts are so protective of the legal process itself.
Sounds good. Let's get into it.
Okay, so the basics. This case involved a victim who was 17 when it reached the High Court, but she was only 15 when the alleged crime happened.
Right, and the accused, he was 25. The charge was that he lured her and committed sexual assault.
And crucially, she had already testified in the trial court. She was PW1, the main prosecution witness.
Yes, she'd given her evidence. But then she filed this petition asking to be recalled to basically testify again.
Why? What was her reasoning?
Well, she claimed her first statements were made under police pressure and also because of some kind of mistake. She was now saying she didn't actually have any complaint against the accused anymore.
Okay, so how do the courts react to that?
Well, first, the trial court, the fast-track special court that handles these POCSO cases, they dismissed her petition. They looked into it and found essentially no convincing evidence she'd been pressured.
So they didn't buy the pressure argument?
No. And then she took it up to the High Court. And this is where it gets interesting. The High Court noted that this petition wasn't filed by the prosecution, but by the victim herself. And it looked very much like a compromise had been reached with the accused.
Okay, so it seemed less like a genuine change of heart and more like a deal.
That seems to be how the High Court viewed it. They were quite blunt, saying that allowing her to be recalled under these circumstances would seriously damage the credibility of the whole judicial process. Their words were it would make a mockery of due process of law.
Wow, strong words. And what about her age? Did the fact she was still a minor, 17, play a role?
Absolutely critical. The High Court was unequivocal. Her consent, her willingness to sort of drop the case or change her story, it held no legal value because she wasn't yet 18, the age of majority.
So even if she wanted to compromise, legally, she couldn't.
Exactly. At 17, her request to alter testimony, especially in a way that clearly helped the accused, just wasn't seen as credible on its own. The court basically saw it as an attempt by the accused, likely working through her and her parents, to manipulate the proceedings.
Right. Does it usually matter who asks for the witness recall? Like the accused versus the victim?
That's a good question. The High Court addressed that too. They acknowledged that often it is the accused trying to recall a witness, maybe to poke holes in their story later.
Yeah.
But they clarified that the strict legal principles apply no matter who's asking. Once a witness has given their main evidence and been cross-examined by the defense, you generally can't just bring them back to contradict what they already said under oath.
It makes sense. Otherwise, people could just keep changing their stories.
Precisely. The system can't really allow a witness to potentially get away with giving false evidence just by later saying, oh, I was pressured or I made a mistake. There has to be finality.
And I remember reading there was a procedural issue, too. Something about the prosecutor.
Yes, that was another key point. The public prosecutor, who represents the state in these cases, explicitly told the court that even if the victim was recalled, they wouldn't conduct any further examination.
Okay, so the state wouldn't ask her any more questions. Why is that significant?
Because it creates a kind of legal impasse. The court itself isn't supposed to step in and conduct a detailed reexamination of the witness in that way. So if the prosecution isn't asking questions, what's the point of recalling her?
It suggests the real goal wasn't just clarification.
Exactly. The High Court concluded the actual intention here was probably just to give the accused another chance to challenge her original testimony, the testimony she gave before any alleged compromise.
So it was seen as an attempt to sabotage the prosecution's case, basically.
That's the essence of it.
Yeah.
The court stated very clearly they can't allow parties to undermine the judicial process by getting witnesses to backtrack on their sworn statements like this.
So bringing this all together, what's the core message for you listening? This ruling really seems to underscore the legal system's commitment to protecting its own integrity, right?
Yeah.
Especially with vulnerable people and serious crimes.
Absolutely. What's fascinating, I think, is watching the court try to balance these competing interests. On one hand, you have potentially evolving perspectives, especially from young people. On the other, there's this fundamental need for the legal process to be credible and reasonably final.
It's a heavy burden on sworn testimony once you say it under oath.
It carries enormous weight, and courts are understandably very wary of anything that looks like an attempt to improperly influence or undo that testimony later on.
Which leads us and you with a really important question to think about.
Okay.
When a victim, particularly a minor, genuinely wants to change their account, how does the justice system navigate that? How can it protect both the person's agency, their voice, and also the core principles that make a trial fair and reliable? What really stands out to you as the key takeaway here?